Due process is the legal requirement that the state must respect all legal rights that are owed to a person. Due process balances the power of law of the land and protects the individual person from it. When a government harms a person without following the exact course of the law, this constitutes a due process violation, which offends the rule of law. Due process has also been frequently interpreted as limiting laws and legal proceedings, so that judges, instead of legislators, may define and guarantee fundamental fairness, justice, and liberty. This interpretation has proven controversial, and is analogous to the concepts of natural justice and procedural justice used in various other jurisdictions. Due process is not used in contemporary English law, though two similar concepts are natural justice and the British constitutional concept of the rule of law as articulated by A. V. Dicey and others. However, neither concept lines up perfectly with the American theory of due process which, as explained below, presently contains many implied rights not found in the ancient or modern concepts of due process in England. Due process developed from Clause 39 of the Magna Carta in England. When English and American law gradually diverged, due process was not upheld in England, but did become incorporated in the Constitution of the United States, by jurisdiction. Magna Carta. In Clause 39 of Magna Carta, issued in 1215, John, King of England, promised, "No free man shall be seized or imprisoned, or stripped of his rights, or possessions, or outlawed, or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals or by the law of the land." Magna Carta itself immediately became part of the law of the land, and Clause 61 of that charter authorized an elected body of 25 barons to determine by majority vote what redress the king must provide when the king offends in any respect against any man. Thus, Magna Carta established the rule of law in England by not only requiring the monarchy to obey the law of the land, but also limiting how the monarchy could change the law of the land. However, in the 13th century these provisions may have been referring only to the rights of landowners, and not to ordinary peasantry or villagers. Shorter versions of Magna Carta were subsequently issued by British monarchs, and Clause 39 of Magna Carta was renumbered 29. The phrase due process of law first appeared in a statutory rendition of Magna Carta in AD 1354 during the reign of Edward III of England, as follows: "No man of what state or condition he be, shall be put out of his lands or tenements, nor taken, nor disinherited, nor put to death, without he be brought to answer by due process of law." In 1608, the English jurist Edward Coke wrote a treatise in which he discussed the meaning of Magna Carta. Coke explained that no man shall be deprived but by legem terra, the law of the land, that is, by the common law, statute law, or custom of England, by the due course and process of law. Both the clause in Magna Carta and the later Statute of 1354 were again explained in 1704 by the Queen's Bench, in the case of Regina v. Patty. In that case, the House of Commons had deprived John Patty and certain other citizens of the right to vote in an election, and had committed them to Newgate Prison merely for the offence of pursuing a legal action in the courts. The Queen's Bench, in an opinion by Justice Powys, explained the meaning of due process of law as follows: "It is objected, that by Mag. Chart. C. 29, no man ought to be taken or imprisoned, but by the law of the land. But to this I answer, that lex terra is not confined to the common law, but takes in all the other laws, which are in force in this realm, as the civil and canon law." By the 28 ed. 3, c. 3, there the words lex terra, which are used in Mag. Char, are explained by the words due process of law, and the meaning of the statute is that all commitments must be by a legal authority, and the law of Parliament is as much a law as any, nay, if there be any superiority, this is a superior law. Chief Justice Holt dissented in this case, because he believed that the commitment had not in fact been by a legal authority. The House of Commons had purported to legislate unilaterally, without approval of the House of Lords, ostensibly to regulate the election of its members. Although the Queen's Bench held that the House of Commons had not infringed or overturned due process, John Patty was ultimately freed by Queen Anne when she prorogued Parliament. English law and American law diverged throughout centuries of British history. Many laws and treatises asserted various requirements as being part of due process or included in the law of the land. This view usually held in regards to what was required by existing law, rather than what was intrinsically required by due process itself. As the U.S. Supreme Court has explained, a due process requirement in Britain was not essential to the idea of due process of law in the prosecution and punishment of crimes, but was only mentioned as an example and illustration of due process of law as it actually existed in cases in which it was customarily used. Ultimately, the scattered references to due process of law in English law did not limit the power of the government. About this, American law professor John North wrote that the great phrases failed to retain their vitality. North points out that this is generally attributed to the rise of the doctrine of parliamentary supremacy in the United Kingdom, which was accompanied by hostility towards judicial review as an undemocratic foreign invention. Scholars have occasionally interpreted Lord Coke's ruling in Dr. Bonham's case as implying the possibility of judicial review, but by the 1870s, Lord Campbell was dismissing judicial review as a foolish doctrine alleged to have been laid down extrajudicially in Dr. Bonham's case, a conundrum that ought to have been laughed at, lacking the power of judicial review. English courts possess no means by which to declare government statutes or acts invalid as a violation of due process. As a consequence, English law and American law diverged, with American legislators possessing no means by which to declare judicial invalidation of statutes incorrect. In 1977, an English political science professor explained the present situation in England for the benefit of American lawyers. An American constitutional lawyer might well be surprised by the elusiveness of references to the term due process of law in the general body of English legal writing. Today one finds no space devoted to due process in Halsbury's Laws of England, in Stevens' Commentaries, or Anson's Law and Custom of the Constitution. The phrase rates no entry in such works as Stroud's Judicial Dictionary or Wharton's Law Lexicon. Two similar concepts in contemporary English law are natural justice and the British constitutional concept of the rule of law as articulated by A. V. Dicey and others. However, neither concept lines up perfectly with the American conception of due process, which presently contains many implied rights not found in the ancient or modern concepts of due process in England. United States. The 5th and 14th Amendments to the United States Constitution each contain a due process clause. Due process deals with the administration of justice, and thus the Due Process Clause acts as a safeguard from arbitrary denial of life, liberty, or property by the government outside the sanction of law. The Supreme Court of the United States interprets the clauses as providing for protections: procedural due process, substantive due process, a prohibition against vague laws, and as the vehicle for the incorporation of the Bill of Rights. Various countries recognize some form of due process under customary international law. Although the specifics are often unclear, most nations agree that they should guarantee foreign visitors a basic minimum level of justice and fairness. Some nations have argued that they are bound to grant no more rights to aliens than they do to their own citizens, the doctrine of national treatment, which also means that both would be vulnerable to the same deprivations by the government. With the growth of international human rights law and the frequent use of treaties to govern treatment of foreign nationals abroad, the distinction in practice between these two perspectives may be disappearing.